Please rise. The United States District Court for the Western District of Washington is now in session. The Honorable Richard A. Jones presiding.
Good afternoon. Please be seated.
We are here in the matter of the American Freedom Defense Initiative et al. Versus King County, cause number C13-1804, assigned to this court. Counsel, could please rise and make your appearances for the record.
David Ushami on behalf of the plaintiffs.
Good afternoon.
Good afternoon, Your Honor. Robert Muse on behalf of all the plaintiffs.
Good afternoon to both of you. Please be seated.
David Hackett on behalf of King County.
Good afternoon.
Good afternoon. Linda Gallagher, also representing King County.
Good afternoon to you as well. Counsel, we are here on the respective motions provided by the parties, and the court's going to give each side 30 minutes to make your argument to the court. And before you begin, I have preliminary questions I'm going to ask each of you, so I'd ask that we go through that colloquy at the beginning before you begin your argument with the court. So that this is plaintiff's motion, so counsel, if you're prepared to make your argument, please step to the lectern. And once you get your material set, let me know.
Thank you, Your Honor. Yes, Your Honor.
Great. Okay. All right, counsel, first question is, do you believe that protected speech includes a false or misleading content? Do you believe that's ever permissible?
The answer would be, a state can enforce truth restrictions, that is to say, restrictions against false or misleading statements in the context of commercial speech, where you're dealing with the sale of goods and services. As we will certainly address in the oral argument, under New York Times v. Sullivan, that standard cannot be applied to political speech, where you're engaged in speech that includes facts, but oftentimes includes hyperbole and includes opinion. It would be almost impossible, as we will see in this case, to apply what we normally see in the context of truth or deception type of standards in anything other than commercial speech. And if we boil that down to the actual First Amendment question, in a commercial speech forum, the state has a compelling state interest to protect against misleading the public in the sale of goods and services. As such, it is permitted to issue statutes and regulations against fraud, against misleading consumer statements, but they have to be narrowly tailored and focused to address the specific issue. Once you move away from the sale of widgets or services and into the area of political speech, terrorists are mostly from Islamic countries. America is a colonial oppressor. I'm making a kind of factual statement, but because it's so permeated with opinion, it would be impossible for the state to begin to regulate that in any way that would not be violative of the First Amendment under New York Times v. Sullivan.
Now, counsel, you're clearly aware that the court's already ruled that the advertising that's allowed or permitted in the Metro Transit system is a limited public forum. So with this court having made that determination previously, I'm asking, in the context of a limited public forum, do you believe that protected speech includes false and misleading statements?
Again, even in a limited public forum, the distinction for truth or falsity as a permissible regulation by the state would be for commercial speech, but it would not be for political speech. But I would say, Your Honor, if I may, and one of the issues that I would like to get into in the oral argument here today is the very question of whether or not the bus panels on the King County Metro system remain limited public forum. It seems from the record the landscape has changed dramatically and literally at 180 degrees and then back 180 degrees. That is to say, throughout the period from this court's decision until today, King County has made a reversal, not only in its regulations, but in its practice. It has opened up its buses to highly controversial discourse in many, many different subject matters, but especially in the question of the Middle East debate. Once you've opened up the controversy, as Metropolitan points out in the Second Circuit, you can't then begin to carve back, because that begins the very slippery slope of viewpoint discrimination.
Let me ask another question, counsel. In the context of the case before this court, do you believe that the content of your ad contains any false, any demeaning, or any disparaging content whatsoever?
Could you just repeat the question, Your Honor? I'm a little...
In the context of this case, I'm sorry, counsel, in the context of the facts before this court, and the context of the specific ad that was proposed by your client, do you believe that there is any component of the ad that contained any false, demeaning, or disparaging content?
No, Your Honor. And indeed, that goes to the question of whether or not the policies themselves are being reasonably applied, either because they are inviting viewpoint discrimination or, directly to Your Honor's question, have they even applied their own standards properly? Our position is no.
And let me ask you this, counsel. Looking at the specific ad, the ad your client proposed suggests up to a $25 million reward. Now, and I think it also goes on if you can help capture one of these jihadis. Now, isn't this false if some of the individuals do not have a State Department reward that's available for them? And I think in your own materials that you provided to the court, some of those individuals have rewards for dollar amounts that go all over the place, and some individuals have no dollar amount that's even associated with the notice for their arrest or their desire for capture.
The ad itself that our client proposed does not, first of all, it refers to the FBI, but it also cites to the State Department website, contact information. My client is not selling the program. She made a representation in this ad regarding the rewards program, the fact that the government, both the FBI and the State Department, are involved in, and the fact that the rewards program itself allows for up to $25 million. That the language, one of these, refers not just to the pictured one of these, but again, in political speech, which, by the way, King County insists this is, because they bring to it all types of inferential messages about terrorists, who they are, what type of demographics they come from, what countries they come from, which the ad doesn't speak to. They recognized in their very criticism of the ad that it is political speech. All this ad does is point to the fact that there is a rewards program. The government takes these global terrorists seriously. Here's the pictures, representative pictures of the global terrorists that even the government has posted, and this program allows for up to $25 million. That the words one of these, the reader might believe is exactly one of those? Two answers to that. One, it wouldn't be a material misrepresentation even if I were selling widgets, because what would you do as a reasonable and prudent consumer? You would turn to the State Department and you would ask them, are the rewards still good for these individual men? It says up to. What are the exact rewards for each of these? There wouldn't be any reliance. It is not a material misrepresentation of any fact, even in a commercial speech context. But I return to the fundamental point. This is political speech. It was meant as political speech. Everyone knows that the FBI ran the same fundamental ad, and then they took it down when there was literally a peep of controversy by two American or Washington-based Muslim organizations, which have their own advocacy to pursue, and a congressman who has his own political constituency to satisfy. Those 3 communications was sufficient to generate enough response from the King County Transit Authority and the State Department to remove the ad. Our clients simply put the ad back up to make an important political point.
All right. When you say it's not misleading, counsel, what happens to the individual who sees the ad and has reason to believe that they can make a certain dollar amount if they act upon their request for assistance to go out and provide information about these individuals? And no one can control how aggressive someone will be in terms of acting upon trying to go out and catch a terrorist. I think it would be foolhardy for someone to go out and try and apprehend someone, but we don't know what people will do in today's society. So isn't there room to be concerned that the misleading information about what the possibilities of a reward could be for the general public?
The answer to that, in this particular case, absolutely not. And the reason is this. In all commercial speech, in areas that I litigate in day out, when there's claims of fraud or misrepresentations on IPOs, on prospecti, on all of these commercial speech cases where we're inordinately careful to guard against deception or misrepresentation, the standard is always, what is a reasonable, prudent person going to understand from this ad? Is there going to be a reasonable likelihood of reliance? Are the statements materially misrepresented? The answer to that would be, in both instances, no. No reasonable and prudent reader of that ad is going to say AFDI, because it cites that it's not a government ad, is clearly pointing to a government program. I'm going to run out to Afghanistan and try to locate a terrorist, one of these global terrorists, thinking that any one of them might provide $25 million, because that's not even what it says. It says up to $25 million for one of these. It doesn't say which one. It doesn't articulate the terms, the standards. What do you have to do to earn the $25 million? Simply say, I found a terrorist in Afghanistan. You are going to turn to the source, and the source is provided in the ad. You're going to turn to the source, or you'll do what everyone else does in modern society. You'll Google. You'll find out that the FBI and the State Department have 2 full sets of websites with information and contact information about what and how to do it. No reasonable consumer is going to rely on a bus ad to engage in some behavior as a result of a reliance.
And counsel, part of the ad makes reference to these jihadis. And my question is, can you point to anywhere in the record or evidence that confirms that every one of the persons in your ad referred to themselves as jihadis, or that they performed terrorist acts in the name of jihad? Now, I'm talking about, for example, I think the individual's name is Abdal, Aziz, Aziz, Auda, Awda. He was wanted for conspiracy regarding Palestinian Islamic jihadis. But can you point to any particular circumstances which would verify that these individuals, in fact, are jihadis, other than just a stereotype implication because of their ancestry?
In the record, we can get into that if you'd like, on the actual wanted posters, and we provided this in our motion, you can actually read not only their organization affiliation, but what they're wanted for. In many of those cases, at least in several of them, as you pointed out, I think at least in this one case, and there's others, the actual word jihadi is used. But what we do know, and as we pointed out in the footnote in our reply brief, that the federal courts have recognized that these groups use that term themselves. That's how they describe themselves. They are jihadis in their own discourse and in their own nomenclature. That's not something that my clients made up or the federal courts made up. Those decisions are clear that these are the jihadis, and in fact, in one instance, in several instances rather, and including the Ninth Circuit, the court talks about jihadis and the jihadist war, jihad.
Okay, well,
There is no evidence in the record that any of these individuals are in fact not jihadis. Given the organizations that they have, we would ask the court to take judicial notice of the fact that these organizations are well known among counterterrorist specialists who write publicly and who publish on websites and in professional journals. Each and every one of those organizations self-identify as jihadis. That's certainly an assertion that my client is at least implicitly making by calling them jihadis. What we don't have, and this again is the problem with trying to apply truth or falsehood to political speech. What we don't have in the record is anything from King County that remotely suggests that they're not jihadis.
Counsel, isn't the burden upon the moving party as opposed to shifting it to the defendants to come forward with evidence to the contrary?
No, Your Honor, not when it comes to the First Amendment and political speech.
That's
When my
assuming-
clients were-
That's assuming we confirm that it is political speech.
Well, that would be true. We would have to ultimately confirm and affirm the fact that this is political speech, but I don't know how else to describe it, especially given the criticism. But even if it were commercial speech, let's just take that position. Even if it were commercial speech, the fact that my clients assert that they are all jihadis based upon what she knows in the public record and from their own designs and their own speech, the state comes in and says, well, we don't know that they're jihadis, therefore it's false. That's not how the First Amendment works, even as to commercial speech. It is the burden of the state to impose a governmental restriction, even in one of the traditional rubrics where you can have restrictions. In one case, fraud, deception. But it is the burden of the government to restrict my client's speech. In fact, that would be the situation we find in England, where we know in the area of defamation, the truth or falsity burden falls on the defendant, the speaker. That is not the case under our constitutional paradigm and under the First Amendment. The government has to establish that the speaker is violating some provision, and they have not in this particular case.
Well, counsel, an interesting case. The government's provided supplemental authority, and I'm assuming you received that one, and that's a Massachusetts Bay transportation opinion. And some of the challenges in that case may be arguably different from what we have before this court at this point in time. But what I find interesting is the head note that deals with whether it was unreasonable to conclude that the plaintiff's advertisements demeans or disparages Muslims or Palestinians. In that case, the court looked at the various interpretations of what jihad is supposed to mean. Now, even the court admitted its common interpretation is referring to radical Islamic terrorists. But the final conclusion of the court, even with that self-admission, was that it was plausible for the defendants to conclude that the AFD pro-Israel advertisements demeans or disparages Muslims or Palestinians. So I say all this background and summarize that case is to return to the original question: is it your position that jihad has only one meaning, and that meaning must be in the context of being associated with terrorists or terrorism? Because the opinion goes on to elaborate on explaining that there are different meanings and contexts that jihad or jihadists can be used, as opposed to just always concluding it naturally must be associated with terrorism.
And the answer is no. It doesn't have just one meaning any more than if I assert that Osama bin Laden was a killer. It could very well be, or a murderer or a terrorist. It could very well be that killer in that context or murderer could be understood to be freedom fighter. That is to say, he was acting for a good cause. But the real question in the MBTA case, the Massachusetts case, which comes under a very unique decision in Ridley, which is an outlier in all of the circuits, and we can talk about that in a moment. But in that particular case, the ad was different. The text was different. It said, in a war between the civilized man and the savage, support the civilized man, stop jihad, support Israel. What the court understood at that point And the court says expressly in the opinion that he recognizes that in any war between the civilized man and the savages, it's contextualized as war, and the court understood that jihad was relating to the jihadists that the federal courts speak to, that my client is speaking to in this ad. But one might have interpreted these things more metaphorically, and jihad might have been also inclusive of a kind of peaceful internal struggle, which is another meaning. And in the context of that meaning, one might conclude, we disagreed of course, but the court ruled this way, that one might conclude that a peaceful Muslim engaged in jihad might have likened him or herself to a savage, and that would have been disparaging. But that's not the case here. We don't have the ambiguity of the language of that ad in this case. We have the faces of global terrorism, wanted posters, the men that the United States government has identified as representative of global terrorists. And as this court knows, of 32 global terrorists with a reward on their head, 30 of them are representative of some Islamic terrorist group. In that context, the use of the word jihad is unequivocal. There's simply no ambiguity. There's no question. In the same way, Your Honor, that when the federal court, when the Supreme Court used the word jihad to describe the war post 9/11, when the Ninth Circuit used the word jihad in the case that we cite in our footnote over and over and over again, it didn't worry. The judges who authored those opinions did not worry about disparaging all Muslims. All Muslims don't engage in violent jihad. But there are those global faces of terrorism that do, and that's what this ad spoke to. Language is always, if I just may, Your Honor, language is always subject to some ambiguity. There is never a word, certainly not a noun and hardly an adjective, that cannot be stretched out of context to demean and disparage everyone. And of course, that's one of the problems that we confront in this case. I'm going to jump, if I may, just to this point. King County suggests that in a limited public forum, and we're not acquiescing to that designation, I think the court will agree with us that this King County bus panels are now a designated public forum. But even assuming their argument that it's a limited public forum, King County takes the view that you've got pro-Palestine, pro-Israel. And somewhere in the middle there's this line. And they say we can't be engaged in viewpoint discrimination because we allow both sides of the argument. Palestine, Israel. We've rejected some pro-Palestinian, we've rejected some pro-Israel. What is the problem with that? The problem is that there are no political subjects of this type, the kind of controversially, emotionally, and visceral grabbing subjects that have one binary line that sets pro and con. In fact, what you have are pro-Zionist Israelis who say Palestine shouldn't exist. You have pro-Israel Zionists who say we can't support a two-state solution. They should either move to another country or remain as they are. You have pro-Israel Zionists who say a two-state solution. You have those who say, I'm pro-Israel, I'm a Zionist. I'm willing to talk about a one-state solution as long as we don't give all of the right of return for the Palestinian refugees and their children and progeny, because that would simply eliminate Israel. Then you have the pro-Palestinian side. Israel's very existence is a violation of our fundamental rights of self-determination. It should be wiped off the face of the earth, either by war or politically. Then you have those pro-Palestinian positions that say, we're prepared to have a two-state solution as long as we control Jerusalem and other important aspects of the territories, including water rights, oil and gas rights, air rights, a military. In other words, Your Honor, this is the spectrum. There's not a single point that King County can say, we've done well, Your Honor. because we've allowed both sides. There is no one or other side. There are any number of viewpoints, and here's what they've done. Here are the two extremes. They've said, through their so-called civility standard, we're going to allow this politically correct medium. All the other view extreme. They can't decide what is politically correct speech. That is what protects, explain in objective terms that the court can understand how you chose between this ad but not that ad.
Let me ask you this question, counsel. On page 14 of your motion, you referenced the United Foods opinion where it criticizes the absence of clear standards guiding the discretion of the official in charge of administering the policy. And I think that's where you're in that field at this point in time. What I'm looking for is, can you point to any clear standards that have been approved by a court that would give the court guidance on what exactly it's supposed to look like?
And I apologize, I must have missed the first predicate of the question.
It was the United Foods opinion?
And you're referencing what page?
On page 14 of your motion?
Okay, yes.
Are you with me now?
Yes, Your Honor, I may.
Okay.
And indeed, I'm going to take it from King County. In 2010, when this court confronted CMAQ, King County operated only under the contract, and that was not atypical, by the way. We've been litigating these cases now for some time. In the early days, a transit authority in the advertising world would oftentimes just rely on the contract that had the various guidelines. It didn't actually formalize them in its own. And that was the situation when CMAQ case came before this court. Before it actually got to the point of a decision and the briefing on the motion for summary judgment, King County had articulated the guidelines that it wished to follow in the form of the 2010 interim guidelines. The court noted that in its opinion. What did the 2010 interim guidelines actually say? Well, let's go to the declaration of Kevin Desmond. And in Mr. Desmond's declaration at Exhibit B, he tells us, he has laid out the history, as it were. And I'm looking now, Your Honor, at Exhibit B,
Just a second, counsel.
which is the document 13 on the ECF stamp at page 18.
Let me catch up with you. And that's the one that begins, actually it's page 2 of 9 in the document itself.
Yes, it does, Your Honor. I'm looking at paragraph 2.3.
All right?
And I'm just going to read it because it is instructive and directly responsive to the court's question. The county's acceptance of transit advertising does not provide or create a general public forum for expressive activities. In keeping with its proprietary functions as a provider of public transportation and consistent with King County Code 28.96.020 and .210, the county does not intend its acceptance of transit advertising to cover its transit vehicles or transit facilities.
Counsel, if you'd slow down, we have a court reporter.
I'm sorry.
Let's start over again. On the line, it reads, the county does not intend.
The county does not intend its acceptance of transit advertising to convert its transit vehicles or transit facilities into open public forums for public discourse and debate. Now, I'm going to pause here. They make that very legalese statement because it's important. Every court, the Supreme Court's decisions in these areas, but importantly, the circuit court, every circuit court, including the Ninth Circuit, has made this fact fundamental. If you open up a forum to controversy, that's not a limited public forum. It doesn't matter what else you might want to throw on top of it by way of exceptions or regulations. Once you open up to controversy, you are in a designated public forum. I continue now in the actual Regulation 2.3. Rather, as noted, the county's fundamental purpose and intent to accept advertising as an additional means of generating revenue to support its transit operations. In furtherance of that discrete and limited objective, the county retains strict control over the nature of the ads accepted for posting on or in its transit vehicles and transit facilities, and maintains its advertising space as a limited public forum. Now here comes the key language. In the county's experience, certain types of advertisements interfere with the program's primary purpose of generating revenue to benefit the transit system. This policy advances the advertising program's revenue-generating objective by prohibiting advertisements that could detract from that goal by creating substantial controversy, interfering with and diverting resources from transit operations, and or posing significant risk of harm, inconvenience, or annoyance to transit passengers, operators, and vehicles. Such advertisements create an environment that is not conducive to achieve increased revenue for the benefit of the transit system or to preserving and enhancing the security, safety, comfort, and convenience of its operations. What is it that the guidelines eliminated? Public issue advertisements. All they allowed, effectively, were commercial ads and government-sponsored public announcements. In fact, Your Honor, in 2011, and I want to apologize, Your Honor, I read from the 2011 policies, not the 2010 interim policies, that they had actually codified the rule. The rule was actually in 2010. I apologize for the confusion. And here's what they wrote if you turn to Exhibit A in Mr. Desmond's declaration. And this is, again, document 13, page 12 of 34 on the ECF file document. It's the first page.
Well, counsel, as opposed to reading into the record, why don't you make your point?
The King County states, the county is adopting this interim policy in order to advance the primary purpose of the transit advertising program, which is to generate revenue to benefit the transit system. The county's experience with transit advertising has led to the conclusion that the display of certain non-commercial public issue advertisements interferes with the primary purpose of generating revenue to benefit the transit system. Exactly right. And that's what all of the circuit courts have said, save possibly for Ridley. That is to say, if you're looking for a clear and objective standard that sets aside a limited public forum, it's one where the transit authority says we're going to allow commercial speech and government-sponsored public announcements, but we're not going to allow political or public controversy or public issue ads, as King County refers to them. And, Your Honor, something else is important to recognize here. All of the early cases, if you look at the Ninth Circuit case, the Children of the Rosary, if you look at the Ninth Circuit case, Di Loreto, both of those cases, the courts were looking at plaintiffs who didn't like the fact that the agencies had said nothing but commercial ads. They wanted to force the transit authority, or in the case of Di Loreto, the public facility that had the fences, to open up those to something other than commercial speech. The court said in those cases, you may not. And you may not because the language of the court, the Ninth Circuit in both those decisions, when a government agency shuts down a forum to only commercial speech and is purposefully avoiding the controversies that we find in this case now for the second time before this court, then it has clearly established a limited public forum. But in every case but possibly Ridley, and I say only possibly Ridley, the courts have said when you open up a forum to controversy, it is a designated public forum because that's what controversy is. That's what it means to say you're in a designated public forum. You're allowing people to engage in rancorous speech to oppose one another. Now, what King County would like to say, based upon this court's decision in CMAQ, is, well, yeah, we can do that. We can take this public discussion, this controversial subject matter of Palestinians and Israelis, and we can somehow reduce the viewpoints down to an accepted range. That's what the civility does. But that, by definition, is violative of viewpoint discrimination, because they're saying these viewpoints out here are unacceptable, and these viewpoints out here are unacceptable. And in fact, if we turn to the very issue that King County has said is problematic in terms of disparaging or causing a disruption in the ads at issue here, in the FBI Global Faces of Terrorism, the claim is somehow that if you look at those faces, the reasonable and prudent viewer is going to say 16 faces, black, brown, Islamic, come from Pakistan, Saudi Arabia. Therefore, this ad must be saying that all black faces, brown faces, Islamic faces must be terrorists. Now, the standards that they're applying at least make lip service to community standards and the reasonable, prudent person. I dare say that I'm not from Seattle. I'll root for the Seattle Hawks, but I'm not from Seattle. I dare say that the people of Seattle are not going to simply assume, because they understand that these are the faces of the global terrorists, that is to say, from the pool of those individuals that the government has decided to put a reward for their arrest or capture, that means that everyone with a brown face or a black face or who's from an Islamic country is somehow a terrorist. But even if it were, let's just accept that presumption. And let's even accept that that is some kind of subliminal message of the ad. It's a political ad. That is precisely the viewpoint that they wish to now say that's unacceptable. If you want to talk about terrorism, we allow you. In fact, they allowed the FBI ad to come in the first time. They claimed they made a mistake, again, like they claimed in CMAQ. But the fact remains is the FBI then ran another ad, took out the pictures and talked about terrorism, so that the subject matter of terrorism is a legitimate area in which to engage in speech. But then they want to say we can impose these restrictions. And by imposing these restrictions, these civility restrictions, we take it out of that designated public forum and somehow push it into a limited public forum. But remember what the circuit court said in New York Magazine v. Metropolitan, which was cited approvingly for this point by the Dioretto case and by the Children of the Rosary. If a government agency can allow controversial speech, therefore opening up a designated public forum, and then throw on top of it some other restrictions like civility or what have you, and then somehow pull it out of the designated public forum, you've eviscerated the designated public forum. There is not a transit agency in the world that doesn't have those. Indeed, and I'd like to correct a misconception that might have been understood in the CMAQ opinion, but it's clearly misunderstood by King County. In Metropolitan, the New York Magazine v. Metropolitan, at issue in that case, in the record, were transit authority standards that include all the kinds of standards we see here. No tobacco, no firearms, no minors, no obscene material, no disparaging of an individual, group, nation, race, what have you. You had all of those. And even though you had all of these restrictions, the court said, once you've had controversial speech, tacking on restrictions to somehow allow you to eviscerate the designated public forum and engage in viewpoint-based discrimination doesn't work.
All right. Counsel, I've let you go on for a period of time now. And are there any other areas? Because I think you've covered quite a bit of material at this point in
There
time.
is, Your Honor. And just briefly, if I may, and I've already provided a copy. I'd like to just approach to provide the court
Certainly.
with the record in the case American Freedom Defense Initiative versus Metropolitan Transit Authority, because this sets out from the man in charge of the standards at the MTA that at the time of New York Magazine v. Metropolitan, all of the same standards, and they can be found at Exhibit C, with all of the restrictions that are in this case applied in that case. Also, Your Honor, so I don't have to make two trips, I would like to provide, and I've also provided a copy to Defendant's Counsel, the supplemental declaration of Sharon Shinbo, the first decision maker at King County on these advertisements, that she had supplemented in the CMAQ case, what I call CMAQ 1, the motion for preliminary injunction, as opposed to CMAQ 2, the motion for summary judgment, in which she discovered anew some additional ads. And I would like to just be able to look at those with the court to show that in the context of the actual policies, there is no consistency whatsoever. So if I may, Your Honor.
Certainly.
We've spoken about the form issue, and given the fact that the policy has changed, the written policy, from a kind of vague transit authority contract to a 2010 interim policy that said nothing but commercial and government sponsored, because, you know, these public issue ads are controversial and it's detracting from our role as a provider for bus riders. In 2011, that was codified in the rules. Nothing but commercial ads and government-sponsored public announcements. Then in 2012, suspiciously after this court's decision, they decided, even though we've now said twice that these public issue ads are controversial and they detract from our role in providing a good and viable transportation experience and raising revenue through ads, we're going to allow these public issue ads. But what we're going to do is have all these civility standards tacked on top. And through that mechanism, in violation of New York Magazine v. Metropolitan, we're going to try to convince the court, when this day comes, that we could still keep our limited form designation. But if we look at the actual policies, we find even in a limited public form, these policies are not enforced in any way, shape, or form consistently. If you would open up, Your Honor, the supplemental declaration of Sharon Shinbo. Now, these ads also were denied based upon Ms. Shinbo because they weren't true, there was something misleading about them, and because they were somehow disruptive. Now, I look at these ads, and to be honest with you, I can't make heads or tails out of them to know that they're true or false. Hate crimes committed by cults are destroying the U.S. Now, this gets to the court's earlier question. Is that a fact? Maybe. But it's a political statement. There is no way in the world to apply a deception standard to that ad. And when you do, you're clearly violating New York Times v. Sullivan. But what is disruptive about it? What is disparaging about it? It's making a political statement. The same with the next ad, Nazi medical abuse committed for 15 years. Again, I don't know what that means, but it's neither disparaging, as far as I can tell. It's simply saying that someone's engaged in Nazi medical abuse. Who, why, and how, we don't know. These were all rejected by Ms. Shinbo and the King County. Maybe not by Ms. Shinbo, but I'm sorry, but certainly rejected by King County. Again, the next ad has a swastika on it. I find that personally obnoxious, but it's not disparaging. Nazi medical abuse committed for 15 years, it's not disruptive. I'm not going to decide as a reasonable, prudent consumer of the bus system, if that were to run, that somehow we're being, accused of being all Nazis. It makes no sense from a reasonable, prudent perspective. Again, if King County can explain under its rules, under its policies, how this is being applied in an objective, consistent fashion, I would certainly like to hear it. But what you don't have, Your Honor, in Ms. Shinbo's declaration and in Mr. Desmond's declaration, you don't have a single word of explanation. The same holds true, Your Honor. For all the ads, if you turn to Ms. Shinbo's declaration submitted in this case, Exhibit A, King County says the limited public forum hasn't changed. Well, we've already seen that the guidelines have changed radically. Radically. They've done 180 and then back 180. But more than that, the ads and the conduct that King County has allowed has changed. Look, for example, Your Honor, at Exhibit A of Ms. Shinbo's declaration. It's document 14 in the ECF file document, page 12 of 54 at C. I'm a Palestinian. This was accepted January 3rd, 2012, long after CMAQ. I'm a Palestinian, equal rights for all, CMAQ. Anyone engaged in the Palestinian-Israeli dialogue understands what this means. Israel is denying Palestinians equal rights. They've been accused of war crimes as an occupying power. There is an entire global campaign being financed tremendously in Europe and in this country called BDS, Boycott, Divestiture, and Sanction, to impose the same kind of oppressive boycott, divestiture, and sanction that effectively destroyed the apartheid regime in South Africa. And this ad goes directly to that. This is accepted. Disparaging? Of course it is. It's disparaging of everyone who has a relationship to Israel. Is it true? It's also false. I could make a very clear statement that Palestinians, under perfectly normal political conditions, have equal rights. Palestinian Arabs that are citizens in Israel have equal rights. I could make that argument. Is it true or false? It doesn't deserve that. This should have run in a designated public forum, even though I disagree with it vehemently. The same with the next ad. I'm a Palestinian, equal rights for all. Different pictures. The next ad. Equal rights for Palestinians, the way to peace. Now, what does that suggest? It suggests that what is preventing peace and causing war are Israel's policies denying equal rights. True or false? That doesn't apply here. It's political speech. Disparaging? No. This is vigorous public debate. The fact that the ACLU sits in the same room with American Freedom Law Center on the same side of an argument for free speech, for a designated public forum, speaks loudly. We would seldom find ourselves on the same side of a legal dispute. But in this case, we're of the same mind. The same with the other ads. These are all ads that did not exist when CMAQ was decided. Equal rights for Palestinians, the way to peace. Now, here's a kicker. This was accepted on July 1, 2013. This is at page 16 of 54 of ECF document 14. The Palestinian Authority is calling for a Jew-free state, equal rights for Jews. Clearly, this ad, submitted by my client, was in direct response to the equal rights ads. Disparaging? No more or less than the earlier ads. True or false? It's political speech. That makes the point that in a forum of this type, to begin to try to decide what is or is not acceptable, but remember, all of these were acceptable speech. Now, if we go to...
Counsel, I'm going to stop you there.
Yes.
The court has those ads, and the court's given you quite a bit of latitude, so I'm going to ask you to summarize now, and so I can hear from...
Thank you, Your Honor, and I appreciate your indulgence. It is the plaintiff's position that since CMAQ, the record is replete, and it is a record provided by King County itself, that it has changed its policies to exclude all public issue ads and then back again. And during the course of that time, from January 2012 until today, it has allowed one ad after another that involves highly controversial, highly emotional, highly political speech. As such, King County is not a limited public forum, if it ever was, but it certainly is not now. Secondly, even if we were to accept a designation, which we don't, but if court were to rule that King County remains a limited public forum, the policies that have applied in this case have not been applied reasonably or consistently and illustrate a viewpoint discrimination. And specifically, when we see that the ad at issue here is defined as disparaging, when indeed before the FBI was not disparaging, King County's response is, we made a mistake. But they provide nothing by way of the record, no statement by Ms. Shinbo and no statement by Mr. Desmond or anyone else, how it is that they came to understand that what wasn't disparaging became disparaging, which again evidences the inconsistency which allows for this viewpoint discrimination that shrinks the area of public discourse. Thank you, Your Honor.
Thank you, counsel. Counsel, let me know when you're set.
I'm ready, Your Honor.
Okay. First question I have for you, counsel, is one of the things that counsel points out in the briefing is that you've succumbed to what they characterize as a heckler's veto in the administration of your ads. In other words, the initial ad that you approved wasn't rejected by King County, rather it was withdrawn once the number and volume of complaints that came in. And it doesn't appear that there was high volume of complaints. There was a letter that came from Congressman McDermott and a couple other entities and other individuals. Now it appears that there's been some response to that and there's a change. Is this a moving target? And counsel, if you initially approved an ad, is it a question of you responding to just public opinion, and it's the public opinion that helps you formulate what your policy is, or is it in fact the county that has its own policy that you established and that you enforce on your own? I'm a little bit confused.
Well, Your Honor, I don't think this is a case of the heckler's veto. What happened is after Congressman McDermott and other local and community groups raised concerns with the ad, the State Department withdrew its own ad. King County did not make that decision at that point. And then when the AFDI ad came in, initially came in its first blue background form and then came in the revised red background form, at that point it's not so much a heckler's veto, but taking into account information that you know. As Ms. Shinbo points out in her declaration, the county did not fully appreciate how the faces of global terrorism impacted minority communities. Having achieved that information, both through information that was sent to Metro as well as a community meeting that was held by Jennifer Shaw of the ACLU, that was now information for Metro to take into account. I think that Metro would not be acting appropriately under its policy if it froze information to that which was available when it accepted the FBI ad. Instead, it considered all of the information that was available and applied that information in a viewpoint neutral way. It did not matter that AFDI was the organization presenting that viewpoint. The viewpoint did not matter. The problem was how that viewpoint was presented. It was presented in a demeaning and disparaging way rather than simply saying FBI's most wanted or State Department's most wanted, which would have gotten rid of that problem with faces of global terrorism.
Well, counsel, the Hopper opinion, H-O-P-P-E-R, indicates that consistency in the application is the hallmark of any policy designed to preserve the non-public status of a forum. So do you in fact have consistency in the interpretation and application in the context of the first ad compared to the second ad in your treatment?
I do believe so, because the information changed in the interim. The Hopper decision is interesting, though, because that was a case where the city of Pasco, as Hopper points out repeatedly, really had no standards. They simply had a letter to their vendor saying, please don't put anything controversial on our walls. And when something was put on their walls that they considered controversial, they had no standards to apply at that time. So it was a situation where the Ninth Circuit was pointing out that you had an attempt to create a limited public forum with absolutely no written standards surrounding that, and thus no opportunity for consistency. In contrast to that, King County has developed a lengthy, written, and objective policy that includes things like demeaning and disparaging, false and misleading, as well as general categories of speech. Under the Ridley case, it's pointed out, and I think this is consistent with Hopper as well, that a few instances of misapplication, particularly when the facts change in between, is not enough to convert your forum to overcome the government's stated intent to create a limited public forum.
Then, Council, let's go specifically to Section 6.2.9 of your policy. And that section talks about the harmful or disruptive section of your policy. Now, it's my understanding after reviewing your materials that you contend the material is so objectionable as to be reasonably foreseeable that it will result in harm to, disruption of, or interference in the transportation system. Now, in CMAQ, which is court handled, I think everybody knows that by now, we had specific threats. We had specific threats that went beyond letters. We had people making statements of what they would actually do if those signs continued to persist. We had statements of outrage and statements of the concern of the drivers in terms of their fear, and I could go on and on and on about the record that was before this court. Don't we find ourselves in a situation where we have an issue of this type, issue meaning the issue of terrorism, just as counsel has alluded to in his argument this morning and also in the briefing, where we have expressions of opposition or someone wants to get their side now before the general public? Aren't we always going to have a case where viewpoints are to be expressed on your buses one way or the other? And how do we avoid a situation where it's subjective, as one at a time we'll look at this, but we may change it for this one, and it gives the appearance it continues to move in terms of your interpretation and management of the policy?
Well, I believe it's important to take specific reference to Mr. Desmond's discussion of that provision in his declaration. And he makes no claim that the AFDI ad will cause harm to or disruption of the transit system. Instead, he is relying solely on interference, which I think combined with demeaning and disparaging and false and misleading is sufficient. But what he is getting at is that the goals of increasing ridership, of increasing revenue, those types of things are interfered with when you do allow demeaning and disparaging speech and false and misleading speech. So I think that is the limit of Mr. Desmond's use of that particular provision. But to get to the court's more basic question, we are not here under the Metro policy to prevent controversial speech. Instead, what we do is we lay the ground rules so that speech has to fall within certain rules, like it can't be false, it has to be accurate, and it can't be demeaning and disparaging to particular groups. The FDI ad is a good example of an ad where if your interest is in catching terrorism, catching terrorists, you put most wanted on the ad. You don't put faces of global terrorism. You don't misrepresent the dollar amount. You don't misrepresent the agency that's providing it. And you don't use the word jihad in its broadest sense to imply that anyone that practices jihad is a terrorist. There are ways to present the message that comply with the policy. And that's why the policy is ultimately viewpoint neutral. It's not about what the message is. It's about how the message is presented. And as long as we have a situation where any side to a debate is under the same rules, then that is viewpoint neutral under the precedent.
That's the only question I have, counsel. You can continue with the balance of your presentation.
Thank you, Your Honor. In this situation, the preliminary injunction should be denied because plaintiff AFDI has failed in its burden in this case. Metro has created a limited public forum for its advertising. That public forum, limited in its nature, was recognized by this court in the CMAQ case and has been strengthened through the subsequent policies that King County adopted. The decision to reject the AFDI ad, as shown in the declarations of Ms. Shinbo and Mr. Desmond, was reasonable and, importantly, was viewpoint neutral. Those are what are applicable to a limited public forum. The court's obviously well aware of the standards for preliminary injunction. I do think it's important that plaintiff's counsel, the plaintiff, has to not only assert that they're irreparably harmed, but actually show some level of irreparable harm in this case. And that would require, as I'll point out in my argument, taking into account alternate means of presenting what they claim is a political message, for instance, sidewalks, other advertising venue like billboards and such like that. In this case, it's important that plaintiffs availed themselves to a limited public forum. Having availed themselves to that limited public forum, they also accept the responsibility of complying with King County's rules. In this case, AFDI has no likelihood of succeeding on the merits because Metro has created a limited public forum. And that is truly the crux of this case. If Metro has created a limited public forum with its transit advertising, then it is entitled to be reviewed for reasonableness and for viewpoint neutrality. Reasonableness, as the cases point out, does not require that it be the most reasonable decision, but that it fall within a realm of discretion bounded by that written policy, and that's what Mr. Desmond's decision does. It is clearly stated in King County's ordinance and in its transit advertising policy, as counsel read for you from the 2011 version, that King County intends to create a limited public forum. Indeed, if you looked at the 2012 version, which was in effect when the AFDI ad was presented, it is verbatim, word for word, with what counsel read from 2010 and 2011. The differences with the policies are that come 2012, King County was able to support its position of maximizing revenue by reintroducing public interest and political interest ads, so long as they were subject to the demeaning and disparaging restriction and the accuracy restriction. Mr. Desmond explains in his declaration that the problem you have is trying to strike the right balance between maximizing revenue and not offending your ridership, not leaving your bus as an uncomfortable place to ride to work or to ride home from work, particularly for individuals who have no choice but to take the bus, as well as for those individuals who find the bus more convenient. And by adding those restrictions on civility and those restrictions on accuracy, King County was able to reintroduce political ads. Contrary to what counsel presents, there is no case, particularly in the Ninth Circuit, that says controversy, accepting any controversy means that you automatically have a designated public forum. Indeed, rather than being an outlier, the Ridley case is one of the few circuit cases to address demeaning and disparaging and false and misleading head-on, and it finds that those are viewpoint neutral criteria that are subject to reasonable application, that are not overly vague for First Amendment purposes. The Ridley decision is compatible with what we have in the Ninth Circuit thus far. The Hopper case is decided essentially on the point that the city of Pasco had absolutely no standards. It made it up as it went along. And as the panel in Hopper pointed out, that was inconsistent with a limited public forum because there was no definition to that forum. So with that opening in the Ninth Circuit, this court is free to look to the Ridley precedent, free to look to the recent AFDI case from the District Court in Boston, and very much as Metro did in adopting a demeaning and disparaging and accuracy provisions, following those as part of what is allowed under the First Amendment. We think that is reasonable. In this situation, Hopper says, quote, "Government intent is the essential question in determining whether a designated public forum has been established." In this case, the record is clear that King County has stated its objective to create a limited public forum, and that it has operated its transit advertising in a way to enforce that limited public forum. including altering its policies in order to further strengthen that public forum and to allow a level of speech in that forum that is consistent with ridership. It would be completely ironic, and ironic might not be a strong enough word under the First Amendment, if it was a First Amendment requirement to force Metro to preclude all public interest speech rather than simply impose a civility requirement. And that's essentially what plaintiffs are asking this court. They're saying you can have no limited public forum unless you exclude all political speech. We believe Metro's approach in its transit advertising is consistent with the First Amendment, certainly consistent with the Ridley case, by allowing a limited amount of public interest speech so long as it meets those demeaning and disparaging and accuracy requirements. Regulations in this case require that all allowed speech on Metro buses, regardless of viewpoint, are accurate, not demeaning and disparaging, and do not interfere with with our bus system. If counsel was to show this court that there is, counsel raises the question, well, why isn't there more explanation in Mr. Desmond's declaration or in Ms. Shimbo's declaration about exactly how they made the distinction between A and B and why they published other certain ads? In this case, that is AFDI's burden. They are the ones that are seeking the extraordinary remedy of a preliminary injunction. If they believe that that decision is bad, it was their burden to put that before the court. Indeed, if you look at A and B, Exhibits A and B to Ms. Shimbo's declaration, we believe that it is certainly within the realm of reasonableness that A, the ads that counsel went over with the court, are all stated in a very positive way. They have pictures of smiling people. They have positive messages, I'm a Palestinian, equal rights for all. The AFDI ad likewise says the Palestinian Authority is calling for a Jew-free state, equal rights for Jews. It is not demeaning and disparaging any group, and it is not demonstrably inaccurate. In contrast, the ads under Exhibit B are well characterized by the violent images that permeate these ads. The loaded websites, www.stopislamicapartheid, www.stopjewishapartheid.com, all accompanied by very inflammatory, very demeaning and derogatory, violent type images. If you were to give these two stacks to anyone, I don't think it would be very hard to get them in the right piles. But in this case, it's not a question of Metro needing to have a perfect record, but rather that it needs to act reasonably. And there is nothing on this record to show that Metro has done anything that acts reasonably in accord with its policy. In this situation, as Mr. Desmond points out in his declaration, these regulations are reasonably related to the purpose of the forum, which is to maximize advertising revenue to support a bus system. Unlike other cases cited by plaintiffs, this is not a situation where expression is part of the reason that we have the forum. The purpose of the forum is simply to make money and to operate a convenient bus system for the benefit of the passengers. And allowing that advertising provides some 3.8% of revenue to Metro, I believe, is the figure in the declarations. It accomplishes that purpose. Under this policy, rejection of the AFDI ad was both reasonable and viewpoint neutral. As the court has pointed out, the ad simply was not accurate. The language that the FBI ad adopted, or the State Department ad rather, was changed. It was changed in material ways to make the reward substantially overstated. No single wanted terrorist on the list with their picture posted was worth $25 million. Now, it may be far-fetched that someone would take off on an international expedition trying to capture one of the persons in that picture, but certainly it would not be fair to that person either to have them capture their terrorist and find out that he is only of the $1 million variety as opposed to the $25 million that AFDI promised. Again, it was the State Department and not the FBI that was the sponsor of the ad. That was also something that misled from the AFDI advertisement. The ad was also demeaning and disparaging. Faces of Global Terrorism suggested to the public that they should be on the lookout for any person of color with an Islamic name or Islamic dress. It relied on stereotypes, and those types of stereotypes, as we learned in response to the FBI ad, were demeaning and disparaging to members of various minority communities within the Puget Sound. With the FBI ad, Metro failed to fully appreciate how that Faces of Global Terrorism motif affected those minority communities. However, in the interim, as Ms. Shimbo explains and as Mr. Desmond explains, we were brought up to speed, so to speak, or had it well pointed out to us that it was a demeaning and disparaging ad by stereotyping minorities and by using that idea that dress and skin color equate with being a terrorist. Ms. Shimbo summarizes those complaints in paragraph 15 of her declaration. I'd like to read this brief portion for the record. The juxtaposition of Faces of Global Terrorism next to pictures of persons of color with Muslim-sounding names or traditional Islamic dress suggested that all similar persons were dangerous terrorists. Individuals with Muslim names and dress represented the faces of global terrorism. One caller pointed out that just to depict men of certain races is not correct and incendiary itself. Another complaint labeled the ad inflammatory and demeaning. They look like people I work with, my family members. I think it is imposing a demeaning view upon us. Those were the points that Metro properly took into account in determining whether the demeaning and disparaging portion of its policy was violated by that ad. And I would submit that Metro's decision in that regard was reasonable under the latitude and discretion the Constitution allows for a limited public forum. Importantly, use of the term jihadist was also demeaning and disparaging. As Mr. Desmond explains in his declaration, jihad not only refers to a violent armed struggle against enemies of Islam, but it also refers to an internal spiritual struggle to essentially try and better oneself. The recent AFDI versus MBTA case from December 20th, 2013 recognizes that it falls within that realm of reasonableness for a transit system to reject an ad in a limited public forum based on the misuse of the word jihad. And in that situation, it was an easy fix for AFDI. They resubmitted the ad with the word violent jihad. That would certainly clarify it and avoid the demeaning and disparaging manner it was used in the current ad. In this case, AFDI has failed its burden through its preliminary injunction to show that the Metro decision was anything but reasonable. This is also a situation where the Metro decision was viewpoint neutral because the same rules apply to all. Now, I agree with counsel that it's overly simplified to say that the Middle East conflict is binary, that you're either for or against it. There are all sides to all sorts of debates. But the point of the Metro policy is that wherever you fall on that continuum, wherever you fall on that line, it is your duty and obligation to debate that issue, if you wish to debate it on our buses, in a way that is not demeaning and disparaging, in a way that is not demonstrably inaccurate, in a way that does not use profanity, in a way that does not include images of alcohol, for example. There are limits to what you can do on the bus in order to make the advertising revenue generated consistent with the primary goal of increasing and maintaining ridership on our system. It's important to note that this is not a situation as we had in the Rabb versus St. Paul case, where one side was allowed to fight under one set of rules and another side had to use another set of rules. This was also the situation in Ridley with regard to the drug ads, where only, I believe it was, anti-drug ads were allowed, but pro-drug ads weren't. In that situation, you have the famous Marquis of Queensberry quote, where you can't allow one side to essentially be a street fighter and the other one to play by very formalized rules. Metro's policy does not run into this problem because it imposes the same set of expectations related to civility, to not presenting demeaning and disparaging speech, to presenting accurate speech on all parties that choose to advertise on our buses. So overall, AFDI has failed in its burden to show that it has a likelihood of success on the merits. AFDI has also failed in its burden to show irreparable harm. As I noted above, there are numerous advertising outlets available in this day and age. Taxi cabs. I've even seen advertisements on the back of bathroom stalls in bathrooms. It seems everywhere we go there is an opportunity to present advertising. Certainly, as the articles we have attached in our supplemental materials show, AFDI has been very much publicizing its position on the internet to great success, including using it for fundraising, which is good for them. But that does not show irreparable harm. Instead, it shows that they have many outlets beside the buses while this case is resolved. Furthermore, they have the ability to reapply with a corrected ad at any time, as they did in the Boston case, as we presented in the supplemental materials. I think it's pretty clear what the roadmap is for an ad that does not offend Metro's policies, and it will be up to AFDI if they wish to do that. But the point for irreparable harm is they have the ability to submit a complying ad that presents the same exact message, but in a non-demeaning and disparaging manner. And finally, public interest. Under the Lehman case, it's important to keep note that we are talking about individuals who sometimes have no choice but to ride the bus, and other individuals who find it really a part and parcel of their daily living to take the bus. That is a captive audience. The Metro policy is there to protect those individuals as well as to promote ridership. People are not going to ride buses if they are subject to debate that is demeaning and disparaging, that is inaccurate, that it essentially makes the morning commute and the afternoon commute entirely unenjoyable. And so for the fourth criteria, public interest, that AFDI has failed in its burden to show that that weighs in their favor either. In this case, the court should deny the preliminary injunction. We would refer the court to the motion for stay that we have filed. We do believe that eventually the Ninth Circuit will rule on the CMAQ case and provide some additional guidance to the court, which I think would help the parties in their efforts to further litigate this matter. The court began this by asking counsel for AFDI, does protected speech include false or misleading speech? And counsel's plea was that political speech under New York Times versus Sullivan is always protected. Well, as the court intimated, New York Times versus Sullivan is not a limited public forum case. And in the situation of a limited public forum, you subject yourself to higher regulation by the government accepting the advertising. In that situation, as Ridley points out, and as the district court in Boston points out, it is reasonable for a government accepting speech into what would otherwise be a closed forum to put limitations on that speech as long as they are reasonable and as long as they are viewpoint neutral. In that situation, it is reasonable to limit false speech. That's certainly what is held in Ridley. In that situation, it's always open to AFDI to choose to go to a non-limited public forum. Having availed themselves to that King County forum, AFDI cannot complain that it does not have the full rights that would be available to it in an open public forum, as in New York Times versus Sullivan. So for these reasons, we believe that King County has convincingly established a limited public forum that strikes that crucial balance between the experience of riderships, the need to provide revenue for our system, and allowing a appropriately limited degree of speech in a way that is reasonable and viewpoint neutral. We would ask the court, therefore, to deny the preliminary injunction.
All right. Thank you, counsel.
Thank you.
Counsel, let me ask you just a couple of questions. Counsel's raised the issue on irreparable harm, and it's actually one of the questions I wanted to get to, but didn't. It's just a fundamental question. What would prevent your client from resubmitting the article or the ad, recognizing that these are perceived deficiencies in the ad or objectionable components of the ad, and just resubmit it and just fine-tune the ad? It doesn't appear that some of these changes would be dramatic differences in terms of the content and viewpoint that you're trying to get across.
Well, there would certainly be no physical impediment, but one thing that we have is the King County Transit Authority telling us that the faces of global terrorism, the very essence of the ad, is a problem. It's disparaging. They also tell us that the word jihad in that context is disparaging. But that's viewpoint. That is my client's viewpoint. And so they wish to discriminate on that particular viewpoint. And I'll just come back to the same question that we had at the beginning of the oral argument. I'll keep it short because the court was indulgent. King County Council stood here and said there's no cases that say that if you open your forum up to controversy, that means that you can't then restrict certain aspects and still have a limited public forum. Well, I would address this court's attention to the last Ninth Circuit opinion on the question, DiLoretto versus Downey Unified School District, which we've cited, 196 F. 3rd 958. And there the court says, and I'm quoting, and by the way, Your Honor, and this gets to the question of the stay that King County has asked for, Chief Judge Kaczynski was on this DiLoretto panel, and he happens to be on the panel on the CMAQ appeal. I'm quoting, government policies and practices that historically have allowed commercial advertising but have excluded political and religious expression indicate an intent not to designate a public forum for all expressive activity, but to reserve it for commercial speech. And he then cites to Lehman. The court then goes on. However, where the government historically has accepted a wide variety of advertising on commercial and non-commercial subjects, courts have found that advertising programs on public property were public fora. Not only has King County opened its bus panels to a wide variety of non-commercial speech, but he stood here, the council stood here at the podium and said, we've opened it up purposefully to controversial speech, but we simply want to somehow redact the viewpoints. And I'll end on this, Your Honor. Council conceded that public issues aren't binary. There's not a litmus test, yes or no. And then he tries to make a kind of time, place, manner argument that we can restrict all viewpoints, properly so, because we're not really addressing viewpoint, but how you articulate. But we've seen in this particular case that's not true. The ad says the faces of global terrorism. It is my client's position. It is her viewpoint that these are the faces of global terrorism. Why does she have that viewpoint? For a variety of reasons, but one of which is these are the faces that the government has identified as wanted global terrorists. That's her viewpoint. The only way around that is to deny her viewpoint and say, you can't say that. You can say something else within this narrow band, and that becomes what is obnoxious to the First Amendment. King County wants to know what to do. There's lots to do. Have commercial speech. Have any kind of speech you want. You can even open it up to controversial speech, but you cannot engage in content-based restrictions, much less viewpoint. That's what the Second Circuit said and what the court said in our case, AFDI versus MTA of New York. If you're going to open it up to controversy, even though New York has its own disparagement clause, its own no alcohol, its own no pornography, its own no minors, it has all the kinds of provisions you have in this case. But the court said, as it did in following Metropolitan, once you allow people to engage in controversial speech, the government has no business trying to define what's acceptable within that margin. They want to shut it out like they did in 2010-11, shut it out. But once you open it up to the First Amendment. Thank you, Your Honor.
Thank you, Counsel. Thank you both for your arguments to the court. It's helpful to crystallize your precise positions before the court, as well as the briefing that was provided. So the court's going to try and get determination on this in the next several days. I know that there has been quite a bit of briefing supplied, and one of the options on the stay was out of concern that the Ninth Circuit was going to act. Well, I have no idea what the Ninth Circuit's going to do, and I don't think anybody on the planet does many times. So, and that's not to be disparaging, certainly, of the Ninth Circuit. And I want the record to clearly reflect that. But it's just that we don't know, so that's the reason I want to try and get this order out as quickly as possible, so that eliminates at least one of the concerns that's before the parties. So with that, thank you for being here this afternoon. Have a good evening.
Thank you, Your Honor.
Thank you, Ron.
Please rise.